Good morning. We'll have the review of his fundamental rights. In the previous classes, we have understood thoroughly regarding what are the fundamental rights and what was deleted. Now we'll try to see some more points with respect to the fundamental rights. So I'll go back to article number 12. From there, we'll have a discussion. Just hang on here. I told you when I am talking about article number 12, article number 12 talks about the state. So the definition of the word state has been given in article number 12. I also told you the same definition has been repeated in article number 36. From article 36, we'll be talking about the directive principles of state policy. But let's go through the fundamental rights once again. When I'm using this concept of state here in article number 12, this article mentioned very clearly in this part, meaning in part 3 of the Indian Constitution, unless the context otherwise requires, the state includes, this is what they have said, until and unless the word state is used in other context, the word state includes. You know the meaning of this? I'm just repeating it. The state includes the government and Parliament of India and the government and the legislature of each of the states and all local or other authorities within the territory of India are under the control of a government of India. Anything that is related to the government is a part of the state. I told you already, if there is any authority which is in a position to take a decision and implement the decisions, if because of that decision, if the people are going to be affected, then it is called the state. So this is what is mentioned in article number 12. Let me repeat, the state includes the government and Parliament of India and the government and the legislature of each of the states and all local or other authorities within the territory of India are under the control of government of India. Wherever they are there, if any institution is existing which is under the control of the government, then it is also called the state, right? So now next, when we come to article number 13, I told you already the concept of judicial review. The words judicial review are nowhere mentioned in the Constitution, but the concept is present in article number 32. So according to this article, all the laws that are inconsistent with or in derogation of the fundamental rights are declared to be void. What do you mean by this? Look at this. So this is mentioned under article number 13 of the Indian Constitution. Let's try to understand these articles here. If you look at the first one, the first clause under this article, that is article 13 clause 1, all the laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. Any other law that is already existing in the territory of India before the commencement of the constitution, so these laws are considered to be inconsistent. If they are inconsistent with the provisions of fundamental rights, they are considered to be void, meaning they are no more available for the government, they are no more available in India. And this particular article, clause 1, it has automatically cancelled these laws. And I am talking about all the laws in force in the territory of India immediately before the commencement of the constitution. Next, in the same article, article number 13, clause 2, they are given, excuse me. Article 13, clause 2, I am talking to you. The state shall not make any law. The word state has come into the picture. Kindly go back to article number 12, revise the whole point. The state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. What is the meaning of this? The state has every authority to make any law with respect to the welfare of the people, no issues. But any law, if it is made by the state, if it is contradicting the provisions of the constitution, or if it is taking away the rights that are given by this part, they are considered to be void. Next one, the same article, article 13 clause 3, it explains the words law. They said that in this article, unless the context otherwise requires, law, so they have used this word LAW, law. Law means it includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India for the force of the law. Meaning the word law has included so many things here. It included ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law. Everything is included in the law as far as this particular article is concerned. Next one, the same article 13, clause 3, they have given another one, another subclause, that is B. And here they have explained laws in force. What do you mean by this laws in force? So many times you will come across this word in the newspaper. It said very clearly, it includes the laws passed are made by a legislature or other competent authority in the territory of India before the commencement of this constitution, and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation either at all or in particular areas. Meaning is simple, the laws were made in India before the commencement of the constitution and after the commencement of the constitution. All the laws are existing until and unless they are not repealed. If they are not cancelled, then they continue to be the laws that are present in the force. This is how they have explained very clearly. Now, when it comes to this article number 13, over a period of time, another clause has been added. Another clause has been added, that is another subclause rather. The clause that has been added here, they said that nothing in this article shall apply to any amendment of this constitution made under article 368. What do you mean by this? So this particular one was added through the 24th amendment of the constitution in the year 1971. And accordingly, nothing in this article shall apply to any amendments to this constitution made under article 368. Article 368 talks about the amendment procedure of the constitution, and here they made it over a period of time through the 24th amendment, saying that if anything is done under the article 368, that will not be applicable as far as this particular article is concerned. Now, so from article 14 onwards, kindly remember I told you two articles now. So these are the two articles. One is what is the meaning of the state, and second one is what is the meaning of the law and what is the meaning of law in force. And because of any reason, if there is any issue that is arisen, if it is contradicting the fundamental rights, then that can be declared as void. Next one. So from article 14 to article 32, we have come across with various fundamental rights, and we have seen the original constitution consists of 7 fundamental rights, but over a period of time, one is deleted. Now we have 6 fundamental rights in the Constitution. Look at this. Right to equality, the first one. So starting from Articles 14 to 18, they talk about right to equality. Now look at this article, article number 14. It talks about equality before law. Equality before law. The state shall not deny to any person equality before the law or equal protection of the laws within the territory of India. This is what we have understood in the previous class. Also, there are two concepts that are present. One is the equality before law. Second one is the equal protection of the laws. Both are mentioned in article number 14. And this is with respect to the laws that are made within the territory of India. That is the reason why this particular article is very, very important. Always it comes into the discussion. Look at this. But just remember one point. The concept of equality before law was taken from UK, and equal protection of the laws has been taken from United States of America. That is the only thing. But rest of the things are fine. Just remember this. One second. Now, let me talk to you regarding article number 15. This article 15 talks about the prohibition of discrimination on the grounds of religion, race, caste, sex, or place of birth. Meaning, whenever the state is dealing with any individual, there should not be any discrimination. I told you the meaning of the discrimination. But the Constitution has prohibited the discrimination on the grounds of the religion, race, caste, sex, or place of birth. Look at this. Article 15, Clause 1 says that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. What do you mean by this? Always remember the word state. Immediately recollect all the points that are present in article number 12. And whatever may be the state here, it should not discriminate against any citizen. So during the time, nothing should come into the picture. And the Constitution has expressed this: religion, race, caste, sex, place of birth, or any of them. But in the same article, we have clause 2. I'm reading that. Article 15, clause 2. It says that no citizen on the grounds only of religion, race, caste, sex, place of birth, or any of them be subjected to any disability, liability, restriction, or condition with regard to access to the shops, public restaurants, hotels, and places of public entertainment. What do you mean by this? So whatever the areas I told you, maybe shops or public restaurants, you should not subject any person with respect to the discrimination. Everybody should be permitted to access to the various places. The Constitution has mentioned it very, very clearly. In the similar manner, there should not be any restriction with respect to the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of the state funds are dedicated to the use of the general public. So the wells, these are the places from where the people will get the waters. Tanks, bathing ghats, roads, all these should be open for all the citizens, and nothing like religion, nothing like race, nothing like caste, sex, or place of birth should not come into the picture, because these are being maintained by the state, either completely or partly. Next one. Along with this one, the same article, Article 15, Clause 3, it has given certain special provisions. It said very clearly that whatever we have said above, Nothing in this article shall prevent the state from making any special provision for women and children. Meaning, special arrangements, special provisions can be made by the state with respect to children and women, and this particular section of the society, they have been given they have been given additional respect by the constitution. Hence, states were permitted to make the special provisions to them. That's the reason why when I am talking about the prohibition of discrimination, that is applicable. That is applicable for all the categories. That is the reason why we have used the word sex also during that time. Meaning, whenever I use the word sex, there should not be any discrimination between males and females. So this is the basic idea. But the constitution under article number 15 class 3 permitted for special provisions for women and children. Next one. If you go to next class, nothing in this article of class 2, nothing in this article or something that is present in article number 29, I'll come to this, shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and scheduled tribes. Meaning, special provisions can also be made to the socially and educationally backward classes. At the same time, scheduled castes and scheduled tribes can also be given with the special provisions. And the concept of the special provision was included later, in fact. That was included later, that was added through the first amendment of the Constitution. Originally, it was not there, it was added later. Okay, now, so I am going to article number 16. Hope you are getting this. Article number 15 talks about the prohibition of discrimination. In this similar manner, when it comes to article number 16, this article talks about the equality of opportunity with respect to the public employment. So with respect to government employment, what the constitution is saying, I'll just read it out for you. Look at this. Article number 16 clause 1 makes it very clear. There shall be equality of opportunity for all the citizens in the matters relating to employment or appointment to any office under the state. What do you mean by this? If you look at this one, everybody must be given the equal opportunities with respect to the employment or appointment to any office under the state. Again, we are using the word state, top to the bottom. Any authority, if it is falling under the state, their equal opportunities for all the citizens must be made. Look at this next one. I am talking exclusively about government employment. I told you already, when I use the word public employment, I am talking about the government employment. Article 16 clause 2 is saying that no citizen shall, on the grounds only of religion, race, caste, sex, descent, place of birth, residence, or any of them, be ineligible or discriminated against in respect of any employment or office under the state. What is the meaning of this? Based on the religion, based on the caste, sex, or place of birth or residence, you cannot deny a person for getting into the government job. That is what is the meaning of Article 16 clause 2. Next, in Article 16 clause 3, we have something else. Let's try to see this. Nothing in this article shall prevent the parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the government of India or any other local authority within a state or union territory, any requirement as to residence within that state or union territory prior to such employment or appointments. Meaning, Parliament is permitted to make certain provisions. Similarly, there is Article 16 clause 4. It says that, this is important for us, this Article 16 clause 4 comes into the discussion very, very frequently. Look at this. Nothing in this article shall prevent the state from making any provision for the reservation of appointments. This is the important point for us for the discussion. Article 16 clause 1 is saying that equality of opportunities, and Article 16 clause 2 is saying that don't bring religion, caste, creed, descent, sex or place of birth into the picture. But the same article under clause 4, it is making very, very clear, nothing in this article shall prevent the state from making any provision for reservation for appointments or posts in favor of any backward class of citizens, which, in the opinion of the state, is not adequately represented in the services under the state. What do you mean by this? Number one, according to Article 16, Clause 1 and Clause 2, everybody is being given equal opportunities. There should be no concept of the reservation. But the same Constitution is permitting for the reservations under Article 16, Clause 4. But this is with respect to the backward class of the citizens. And what exactly is the reservations here? If that particular backward class of citizens, in the opinion of the state, is not adequately represented in the services under the state. That is the reason why, starting from beginning, even today also, scheduled caste, scheduled tribes, and other backward classes, they are being provided with the reservations. And these reservations are being provided in accordance with the Constitution, in accordance with the Article 16, Clause 4. Am I clear? Very, very, very important. Now, I'm moving to the next one. I'm moving to the article number 17. And Article 17 talks about the abolition of untouchability. Abolition of untouchability, Article 17. Look at this. Untouchability is abolished and its practice in any form is forbidden. Number one, it is abolished. Number two, its practice in any form is forbidden. What is the meaning of this any form here? Any form in the sense, different mechanisms are there in different societies. Like some may feel that touching physically is nothing but untouchability, or sometimes previously these things were there existing. During history classes, we can understand, if a person walks on a particular road, the others, they never used to use that road. If somebody uses, again there is a concept of untouchability. So during the ancient times, there is something called untouchability by sight also. So many forms are there. Let it be any form that was present in India before the commencement of the Constitution, okay, because nobody has stopped that. But the moment the Constitution came into force on January 26th, 1950, Article 17 has been implemented completely, and this article has completely abolished the concept of the untouchability, and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law. Very, very, very important here. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law. That's the reason today, if anybody practices this untouchability, if that comes to the notice of the state, then action will be taken. Okay. Next one, Article 18, I am talking to you. It talks about the abolition of titles. Abolition of titles. On Article 18, Clause 1, it is mentioned that no title no title not being a military or academic distinction shall be conferred by the state. Meaning is simple, titles should not be given by the state until and unless they are not military and academic. Only two are permitted by the constitution, military titles and academic titles. Next one. Same article, article number 18, clause 2 is making it very, very clear. No citizen of India shall accept any title from any foreign state. It should be very, very clear to us. I was telling you in the previous class, even today also, so many people are receiving the titles from the foreign states. But without the permission of the state, without the permission of the government of India, accepting any title from any foreign state is considered to be a violation of the Constitution of India. Okay. Now, another point, let me tell you, under the same thing, under article number 18, clause 3, no person who is not a citizen of India shall, while he holds any office of profit or trust under the state, accept without the consent of the president any title from any foreign state. Very important here. Even a person who is living in India, if he is not a citizen of India, also no problem. If he is holding any office of profit or if he is holding any trust, he cannot accept any title from the foreign state without the permission of the President of India. Next one. No person holding any office of profit or trust under the state shall, without the consent of the president, accept any present, emolument, or office of any kind from or under any foreign state. Whether he is a citizen of India, whether he is a citizen of foreign, no issues. They cannot accept the title without the permission from the President of India. So see here, if you look at all these articles, articles 14 to 18, these articles are completely talking about the right to equality. At the end of the day, when you come to at the end of each article, the basic concept is same. They are talking about the equality before law. That is what we have seen under various articles starting from 14 to 18. Okay, so now let me talk to you regarding the second fundamental right to freedom. I told you already, right to freedom is mentioned from 19 to 22 of the Indian Constitution. Now let me talk to you about article number 19. Simple one, we have seen already. In article number 19, clause 1, I am talking to you. In that clause 1, again I have subclauses like A, B, C, D, E, right? Now, 19, clause 1, subclause A. It says that all citizens shall have right to the freedom of speech and expression. Yes, we know this. To assemble peacefully and without arms, to form associations or unions, to move freely throughout the territory of India, to reside and settle in any part of territory of India, and to practice any profession or to carry on any occupation, trade or business. We have understood these points. But all these can be practiced only with the reasonable restrictions. Look at this. I'm going to this one, next one, clause 2. Nothing in the subclauses from A of clause 1 shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause. What is the meaning of this? If the reasonable restrictions are imposed, then obviously the state will have the more powers. Kindly remember here, very important, some people will criticize that the constitution is giving the rights on one hand and it is taking away the rights on the other hand. But in fact, every constitution gives the highest priority to the security of the nation. By looking at the security of the nation, security of the people of the country, yes, the state should be given the more powers. That's the reason why they impose the reasonable restrictions. And these reasonable restrictions are applicable for everything that is mentioned under article number 19. Next one. Next one, I am talking to you about article number 20. I told you this one. Protection in respect of conviction. In respect of conviction for offenses. During our discussion, I told you who is called an accused, who is called convicted, and only a convicted person will be given the sentence. We understood these points. Now look at this. No person shall be convicted of any offense except for violation of a law in force at the time of commission of the act charged as an offense, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of commission of the offense. I told you this point here. A person should be given the punishment only in accordance with the law which is present at the time of committing the crime. Number two, no person should be given more punishment than what is prescribed by the law. What is the meaning of this? An individual should be protected even after the conviction also. He can be punished, he should be given the sentence, but only in accordance with the law. The personal things, the personal grudge should not come into the picture. That is the basic idea. Next, article number 20, class 2, it says that no person shall be prosecuted and punished for the same offense more than once. I told you this one. No double jeopardy, meaning one person, one crime, one punishment only. For one crime, single person should not be punished for more than one time. That is the meaning of this. I'll read it for you once again. No person shall be prosecuted and punished for the same offense more than once. Am I clear? Now, next one. In the same article, article number 20, class 3, I am reading now. No person accused of any offense shall be compelled to be a witness against himself. I told you here, no self-incrimination. That's the reason why no person who is accused of any offense, he cannot be compelled to be a witness against himself. So he cannot give witness against himself because he himself is an accused. That is the reason why the judiciary in India will take longer period of time with respect to conducting the inquiry. It takes a lot of time for doing so. Next, I am coming to the next article, article number 21. It talks about the protection of life and personal liberty. So many points I told you in the previous class, but let me go through this once again. No person shall be deprived of his life or personal liberty except according to the procedures established by law. Okay, during this time only, the Supreme Court made it very clear: the right to good environment, the right to privacy, the right to sleep, all will constitute the fundamental rights under article number 21 of the Indian Constitution. Now, later, over a period of time, by amending the Constitution, the number was 86th Amendment. Through that, another article was added, that is article number 21A. And this article talks about the right to education. Right to education. And it says that the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. This is how the Constitution was amended. And whatever the words I have spoken now, this is the matter that is present in article number 45 of the Indian Constitution. And article number 45 is a part of the directive principles of state policy. As long as something is present in the directive principles of the state policy, we cannot challenge the same thing in the court of law. Meaning, DPSP is out of the purview of the judicial review. That is the reason, over a period of time, the subject matter that is present in Article 45 has been shifted to the fundamental rights, and that has been added in the form of Article 21A. And this 21A talks about the right to education. Now, right to education is a fundamental right under the Constitution of India. Now, the state must provide free and compulsory education for all the children between the age 6 and 14. And how you provide it, you decide it. That will be decided by the state. Am I clear? That is article number 21A. I am coming to the next article, that is article 22, clause 1. It talks about the protection against arrest and detention in certain cases. What do you mean by this? No person, I am talking to you about article number 22, clause 1. No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Meaning is simple: whenever a person is arrested, whenever a person is detained, he should be permitted to defend himself, or he should be permitted to consult his friends and relatives. He should also be permitted to have a legal practitioner, meaning a lawyer of his choice. You cannot choose who should be your lawyer. That should be given, the choice should be given to the person who has been arrested. This is what is Article 22, Clause 1. Next, same Article 22, Clause 2 says that every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of a magistrate. What do you mean by this? I told you in the previous class also, once a person is arrested, he has to be produced before the nearest magistrate. Within what time? Within 24 hours, that's it. Meaning, a person cannot be detained in the police station beyond a period of 24 hours. If you want to keep him in the police custody itself, again the permission have the magistrate should be taken. That's the reason why sometimes in the newspaper you will come across with this. If any person is arrested, he is called accused. Either the accused will be sent to the jail, or the accused will be given to the police custody. One is called police custody, second one is the judicial custody. Police custody in the sense, the magistrate is giving permission to the police to take this accused along with the police to the police station for inquiry purpose, for conducting investigation. And when it comes to the judicial custody, the magistrate is ordering that this person should be kept in the jail. Whether police custody or judicial custody, that will be decided only by the magistrate. Since it is mentioned within the constitution, that is followed, that's it. There is no other go. Am I clear? That's the reason why he must be produced before the nearest magistrate. That is the reason conviction will be decided by the judiciary, sentence will also be decided by the judiciary. But the police is acting like a mediator. It's a mediator between the society, the people, and the judiciary. Okay. Now, kindly remember, police do not have any right to give any sentence. Everything will be decided only by the judiciary. Next one. Next one, the same Article 22, Clause 3. Whatever we have spoken in Clause 1 and Clause 2 is not applicable to any person who, for the time being, is an enemy alien. What is the meaning of this? Whatever we have spoken just now, if a person is detained, he should be given the permission to speak and consult his own people, including his legal practitioner, and he should be produced before the nearest magistrate within 24 hours. That is applicable for the people of India, meaning the citizens of India, and this is also applicable even for the people who belong to foreign nations, but not applicable to any person if he is an enemy alien. What do you mean by this? There may be certain countries in the world with which India may not be having the friendly relation. If we may have enemy relations. So if any citizen from that country is caught, he will become an enemy alien. And whatever we have spoken just now, producing him before the magistrate within 24 hours is not applicable for enemy aliens. And if any person who is arrested or detained under any law providing for the preventive detention, sometimes we will come across with the words preventive detention. What do you mean by this? The police will arrest a person before the person commits a crime. So there will be intelligence reported to the police and they will get the information. Accordingly, they will arrest the person well in advance before he commits a crime. And whatever we have spoken under Article number 22, that is not at all applicable to the people who are arrested under the preventive detention. Am I clear? Now I am going to the next article. That is next fundamental right, in fact, right against exploitation. And we have already seen there are two articles under this, article number 23 and article number 24. Look at this, right against exploitation. Every individual should be given highest form of dignity. Excuse me. Every individual should be given highest form of respect. That is nothing but protecting the dignity of an individual. And the individual's dignity should not be violated. If it is violated, that is called exploitation. But that exploitation is not permitted under the Constitution under Articles 23 and 24. We have already seen. Let me give you an explanation here. Article 23 talks about the prohibition of traffic in human beings and forced labor. What do you mean by this? Now let me talk to you now. We have two clauses under article number 23. Let me read it out for you. Article 23 clause 1 says that traffic in human beings and beggar and other similar forms of forced labor are prohibited, and any contraventions of this provision shall be an offense punishable in accordance with the law. I told you the meaning of the traffic. Traffic is nothing but illegal utilization of the human beings. Beggar means it's a form of forced labor. Everything is prohibited under article number 23 clause 1, and if anybody practices this, then the person will be punished. That is considered to be offense punishable in accordance with the law. Am I clear? Next, the same article clause 2, 23 clause 2 says that nothing in this article shall prevent the state from imposing compulsory service for public purposes, and in imposing such service of the state shall not make any discrimination on grounds only of religion, race, caste or class or any of them. Meaning is simple. So we have seen something under article number 23 clause 1, but the same article clause 2 is giving powers to the state. It can impose compulsory service for public purposes. So during that time, it should not be considered as the exploitation. Hope you are getting it. Forcing somebody is a crime, but when it comes to the state, it can impose some compulsory services for public purposes here. If it is for the public good, then there is nothing wrong in the constitution. But if a person is forced to do certain things, then that's a crime under the constitution. Next, article number 24 says that no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. This is what the constitution makes it very clear. Meaning, just how I told you, what is the meaning of a child? Child is a person who is between 6 and 14 years of age. And that is the age for them to have the nutritious food. That is the age for them to go to the schools and have the education, so that the knowledge will improve, so that the person will become the right citizen for India tomorrow. Hence, he should be physically and mentally strong. That is possible only when he is nurtured properly during his childhood. That's the reason for every child, the childhood is very, very important. Proper education and nutritious food. Compulsory. This should be compulsory. This is not the age for them to work in any factory or mine or engaged in any hazardous employment. So there is a separate article in the constitution under article number 21, which is giving complete protection to the child. That's the reason you would have seen so many times. Sometimes you will come across with this: children are employed in certain factories or somewhere. During that time, the concerned authorities will make a right and they will arrest the authorities. They will arrest the organizers of that particular factory or mine. Right? Next one is right to freedom of religion. So far we have seen three fundamental rights: right to equality, right to freedom, and a right against exploitation. Now we'll see one more, that is the right to freedom of religion. In this freedom of religion, it is the freedom of conscience and free profession, practice, and propagation of the religion. I told you the meaning of the profession, practice, and propagation already. Look at this. Subject to public order, meaning it is a responsibility of the state that they should maintain the order. Subject to the public order, morality, and health, and to other provisions of this part, all persons are equally entitled to freedom of conscience and the right to freely profess, practice, and propagate religion. Very, very important here. Every person is equally entitled for freely professing, practicing, and propagating the religion. Very important. Again, Article 25, Clause 2 is saying that nothing in this article shall affect the operation of any existing law or prevent the state from making any law. Meaning is simple. On one side, lots of religious freedom is given. On the other side, we have come across with Article 25, Clause 2, where I have A and B. We will see this. The state can make any law regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice. With respect to all these things, the state can make the laws: economic, financial, political, or other secular activity. Okay, kindly remember this. In India, now seriously debated discussion is going on. Because of this reason only, the Rajya Sabha is getting continuously adjourned. And this is the concept we are talking about, the conversions. And it's a much debated discussion. And after so many years of the commencement of the constitution, Now it is being done very seriously. Hopefully some fruitful things will come out of this. Now at the same time, the state can also make the law providing for social welfare and reforms, or throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. Okay, hope you are feeling this. See here, kindly remember. And if you look at the people who belong to Sikh religion, it's very much permitted. The wearing and carrying the kirpans shall be deemed to be included in the profession of the Sikh religion. That's the reason why. So they will wear and they will carry the kirpans. So there should not be any objection for that, because it is permitted and that is deemed to be included in the profession of the Sikh religion. Okay. And when it comes to this class 2, the reference to Hindus shall be construed as including a reference to persons professing Sikh, Jain, or Buddhist religion. Very important. When we talk about the Hindus, the Sikhs, Jains, and Buddhist religious people, they will also will be coming under the ambit of the Hinduism. And the reference to Hindu religious institutions shall be construed accordingly. Meaning is simple. Hindu religious institutions are not just those institutions what we are looking at today, but the institutions that are related to Sikh, Jain, and Buddhist, they will also be coming under the purview of this, purview of the Hindu institutions. That is Article 25. Next, I am talking to you Article 26. So there is a freedom to manage religious affairs subject to the public order, morality, and health. Every religious denomination or any section thereof shall have the right. Yes, they have every right, but keep in mind public order, morality, and health. And they have every right to establish and maintain institutions for the religious and charitable purposes, to manage its own affairs in matters of religion. Yes, they have every right to manage their affairs. They can own and acquire movable and immovable property. That's the reason why, if you look at some of the institutions there, they are possessing lots of properties, both movable and immovable. Yes, very much permitted by the constitution. And they also have the right to administer such property in accordance with the law. Okay, now next article I'm talking to you, article number 27. It talks about the freedom from payment of the taxes for promotion of any particular religion. I was telling you in the previous class, we have various types of taxes in India, but there is no such a tax called religious tax. And the article 27 reads like this: no person shall be compelled to pay any taxes or the proceeds of which are specifically appropriated in payment of expenses for the promotion or maintenance of any particular religion or religious denomination. This is very important point. Constitution has not permitted for any religious tax. Next, article number 28 says that freedom as to attendance at the religious instruction or religious worship in certain educational institutions. Freedom from attending the places where you are going for the religious instructions or religious worship in certain institutions. What is this? We'll try to see now. No religious instruction shall be provided in any educational institution which is wholly maintained out of state funds. Simple. Wherever any institution which is called education institution which is providing education, and if that institution is wholly maintained out of the state funds, there no religious instruction shall be provided. That's the point. When it comes to the state, state is secular. You know the meaning of the secular. That's the reason why no education institution is permitted to go with the religious instruction. if it is maintained wholly by the state funds. Next, but it is not applicable to an education institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted such institution. Meaning is simple: if it is completely coming out of the state funds, you cannot provide any religious instruction. But as per the law, there may be any institution, any education institution which is established either under endowment or trust. They have every right to go for the religious instructions in that educational institution. Am I clear? Number one, state cannot if the money is completely coming from the state funds. Number two, state should not interfere, but state should not interfere if that particular educational institution is established under endowment or trust. Am I clear? Next, in the same article, the last one, Article 28, Class 3, no person attending any educational institution recognized by the state or receiving aid out of the state funds will be required to take part in any religious instruction that may be imparted in such institution or to attend any religious worship that may be conducted in such institution or in any premises attached thereto, unless such person or if such a person is minor, is his guardian has given his consent thereto. Simple here. There may be any education institution which is recognized by the state, and if it is receiving the aid from the state funds, there, if you want to provide the religious instruction, you are permitted, but the permission, if the person is interested to take up this religious education, yes, he is very much permitted. If he is interested to take part in the religious worship, yes, he is permitted. But if the person is not at all interested, you cannot force him. And if the person is a minor, the consent from the guardian is a must. Meaning, the constitution has tried to provide so much of protection, to the religious freedom. Am I clear? Next right is the cultural and educational rights. Here, kindly remember, I am trying to explain you something that is mentioned in the constitution. That's the reason why deliberately I am going class by class. But with respect to the examination, whatever I have spoken to you regarding fundamental rights in the previous classes, that will be enough. But I'm trying to give you the additional information so that you will have a strong platform. Once you have the strong platform, so it will be easy to understand anything when it comes to the fundamental rights. Right? It's just an attempt from my side. That's it. Next fundamental right, that is a fundamental right number 5, cultural and educational rights. We have two articles here, articles 29 and 30. So we'll look into this. Article 29 says that any section of the citizens residing in the territory of India or any part thereof having a distinct language, script, or culture of its own shall have the right to conserve them. Meaning this article is giving protection for language, script, and culture. Meaning you cannot impose on those people not to practice their language, not to preserve their script or culture. They have every right to conserve them. This is how the constitution tried to protect the interests of the minorities. Next one, if you go to the same article, article 29, clause 2, no citizen shall be denied admission in any educational institution maintained by the state or receiving aid out of the state funds on grounds only of the religion, race, caste, language, or any of them. Meaning, people should not be denied the admission into any education institution if it is maintained by the state funds or if it is receiving the funds from the state. Now, next article, that is article number 30, it talks about the right of minorities. Right of minorities to establish and administer educational institutions, meaning all minorities, whether based on a religion or language, shall have the right to establish and administer educational institutions of their choice. Nothing can stop them from this particular one. Okay, now, so these are the things what we have seen today, starting from article number 12 to article number 30 we have seen. So rest of the articles we'll have a discussion tomorrow. But again, I'm requesting you, please go through all the points what I have spoken to you just now. Accordingly, so you are strengthening yourself. I'm just repeating, understanding the whole constitution is important for cracking the examination in one attempt. And without understanding the constitution properly, getting selected will be delayed. I have repeated so many times. I will be repeating it in even the future also, because that is the importance of the Constitution of India. That's the reason why I am taking enough time. So to make you to understand the whole Constitution. Okay. So thank you so much for being with me this morning, and see you tomorrow morning. Thank you.